Nós vamos iniciar, estamos todos presentes. Peço desculpa porque tivemos um certo atraso, maior do que o habitual para a cultura brasileira, por conta da dificuldade de achar o púlpito aqui, mas conseguimos recuperar o púlpito. Então vamos finalmente iniciar os trabalhos. E o professor Sérgio Guerra, professor titular da FGV, fará a abertura aqui.
Muito obrigado. Eu vou falar aqui de pé, facilita um pouco para eu poder enxergar todos. Vou fazer uma apresentação inicial em português, depois a gente passa por inglês para o professor Matthew entender. I'll speak in Portuguese in the beginning, and after that we change to English in order to understand what we're speaking. Então, boa tarde a todos, uma alegria estar aqui na Procuradoria-Geral do Estado, né, com muitos colegas, amigos, amigas, né, para iniciar uma parceria. Essa parceria ainda vai ser formalizada entre a FGV Direito Rio e a Procuradoria-Geral do Estado, para nós fazermos eventos conjuntos, atividades de pesquisa. Então, isso já é um embriãozinho desse acordo que está para surgir. O doutor Rodrigo Távora pediu que eu fizesse essa abertura aqui, então agradeço muito a deferência de, já dentro dessa parceria, nós estarmos iniciando, então, um primeiro evento em conjunto. I'd like to... First of all, I'd like to say that it's a great honor to be here with Professor Matthew Stephenson, your colleagues and professors and friends, to start this first event that we are co-organizing between FGV Rio Law and the Rio de Janeiro State Attorney offices in Rio de Janeiro. So, the idea today is to have this workshop about the administrative law in the Supreme Court of the United States, the trends and possible influences in Brazil. Né? Então, a ideia é a gente ter esse evento de hoje para nós falarmos sobre direito administrativo na Suprema Corte norte-americana, tendências recentes e possíveis influências no Brasil. A Suprema Corte norte-americana está para julgar alguns casos agora, por esses dias, né? E a ideia é que nós façamos, então, um debate sobre isso. Né? Então, nesse encontro de hoje, nós temos o professor Matthew Stephenson, da Harvard Law School, temos a professora Patrícia Baptista, né, procuradora aqui da casa, né, o professor Vitor Aguiar, que foi o organizador aqui do evento, também procurador do Estado, e o professor André Cyrino também, que está aqui na frente, também procurador do Estado, que vai participar. A ideia é que eu faça uma abertura inicial falando um pouco sobre o modelo brasileiro de agências, e depois o professor Matthew Stephenson falará sobre como a Suprema Corte vem enfrentando os desafios da regulação. E aí depois, então, os colegas farão um debate, eventualmente perguntas ao professor Matthew Stephenson, e, se a gente tiver tempo também, a plateia poderá fazer perguntas à mesa, né? Aqui não tem mesa, né? As pessoas aqui que estão participando dessa abertura. The idea, Professor Stephenson, is that I will make a brief presentation about the Brazilian regulatory state, and after that I will give you the floor and you can make a presentation about the Supreme Court and the trends in regard to the administrative state. Tá bom assim? Então vamos dar início. I'm going to change to English in order to our Professor Matthew understand what I'm speaking. I'll say that the workshop is about the administrative law at the United States Supreme Court. We are here to listen, obviously, and learn with Professor Matthew about the recent trends and possible influences in Brazil. I would say that currently, both the US and Brazil are facing a debate about who do a better job of setting public policy in complex matters, in complex sectors. Congress, regulatory agency, or judiciary? Sorry. That's the debate right now. I mean, in the United States, in here, vou falar rapidamente em português também, nós temos um debate nos Estados Unidos, que já é muito antigo e que vem se acirrando nos últimos tempos, sobre o controle das decisões das agências, sobre o poder das agências norte-americanas, onde lá é chamado do quarto poder, né? E aqui nós também temos esse debate, que no momento está um pouco mais controlado, em função do Supremo Tribunal Federal ter confirmado algumas decisões das agências, Mas lá nos Estados Unidos, especialmente nesse momento, com a mudança da Corte, né, com a mudança, você tem 6 conservadores e 3 progressistas lá, há uma tendência, né, de uma mudança da Chevron Doctrine. Então, é isso que nós vamos falar um pouco nesse momento, e depois o professor Matthew vai fazer os comentários sobre o que está acontecendo nos Estados Unidos. In regard to Brazil, I will present some necessary consideration about the history of the rule of law and the creation of regulatory agency. This legal debate is intelligible in the US, considering that mostly Congress does not bring a clear answer to the meaning of the statute that an agency must follow, expanding the agency statutory authority after Chevron Doctrine. O que está acontecendo, então, como eu disse, nos Estados Unidos, o debate ele circunda muito em função do Chevron Doctrine. É uma doutrina de 1984, onde a Suprema Corte acabou decidindo que para controlar uma decisão da agência deveria ter 2 fases, eu vou explicar isso um pouco melhor, mas o fato é que lá você tem uma doutrina bastante consolidada de 40 anos sobre o controle das agências, sobre a deferência do que as agências, sobre o que as agências decidem ou não. Here in Brazil, we don't have a domestic doctrine like Chevron. We don't have it. In regard to the judicial review agency statutory authority by the Supreme Court. I'd like to start by stating that since the beginning of the Brazilian Republic, with the enactment of the first federal constitution of 1891, the political system adopted the U.S. separation of powers model and the theory of centralized government, or to mention the American doctrinal term, the unitary executive. It means that all administrative activity was controllable by the president. Aqui no Brasil, desde 1891, o nosso modelo é de centralized government, ou seja, desde o início, poder concentrado na mão do chefe do Poder Executivo. Isso desde 1891. In the 30s of the 20th century, Brazilian administrative law scholars began to argue that, given the complexity of society, Brazil should adopt the system of public utility and regulation by agencies in the U.S. New Deal style. Na década de 30, aqui no Brasil, nós tivemos uma pressão grande, alguns doutrinadores importantes, algumas obras foram publicadas nesse momento, dizendo que o ideal naquele momento seria que nós seguíssemos o modelo norte-americano de regulação, com as public utilities, né? Vale nós lembrarmos do Código de Águas brasileiro, onde você teve ali um modelo de public utility, de atividade, de regulação de atividade privada, né? E um modelo de regulação que foi previsto na Constituição de 34, inclusive. So, influenced by the U.S. administrative state, a term used to describe the phenomenon of administrative agencies exercising the power to create, adjudicate, and enforce their own rules, the Brazilian Federal Constitution of 1934 maintained the separation of powers and the centralized government by expressly provided public utility regulation, allowing the government to create several regulatory commissions. Na Constituição de 34, previu-se a ideia de regulação estatal, né? Tem artigo lá expresso dizendo isso. E foram criadas algumas comissões no Brasil naquela época, né? Comissão para regulação do açúcar e do álcool, mate, pinho, frutas. Isso tudo foi criado na década de 30, já com essa influência do modelo norte-americano. As consequence of political conflicts, only 3 years later, the 1937 Federal Constitution of Brazil was promulgated, privileging the centralized government and leaving huge power to the President of the Republic. Em 37 nós tivemos outra Constituição, de novo, já no modelo mais próximo ao ditatorial, né, a Constituição polaca, também, obviamente, focando muito no governo central, nas mãos do chefe do Poder Executivo. After World War II, another constitution was promulgated in 1946, privileging the centralized government. And in 1964, the military dictatorship took over and lasted for almost 21 years. Então, nós tivemos depois a Constituição de 46, após a Segunda Guerra Mundial, e em 64 o golpe militar, obviamente, e aí você tem absoluta centralização. Aqui não está escrito, não vou falar em inglês, mas nós tivemos aí o Decreto-Lei 200, né, que previa uma forte descentralização. Dizem ali que foi a primeira reforma da administração pública brasileira, mas o fato é que o artigo 170 daquele decreto diz que o presidente da República pode avocar o que quiser. Então, manteve-se, de qualquer maneira, a ideia de centralized government. This scenario has changed with the promulgation of the Federal Constitution of 1988, more precisely in the end of the 90s. The impact over the Brazilian centralized government model came with a transplant of the US-style administrative state approach, with the creation of some independent administrative agencies. Em 90, então, com a Constituição de 88, isso mudou, aquela ideia de que nós tínhamos um centralized government, ou seja, um Estado absolutamente centralizado nas mãos do chefe do Executivo, mudou com a criação das agências reguladoras independentes. The creation of regulatory agencies was largely the result of ideas developed during the administration of former President Fernando Henrique Cardoso in 1995. The period was one of economic change with a succeeded economic plan, the creation of new currency, and a huge privatization program. The creation of regulatory agencies was paramount to deal with technical issues and, most important, to attract private capital. The goal at that historical moment was, first, lending some predictability to investors. Second, making the agency protected to the president's discretion. Third, being less vulnerable to conflicts and potential political interest from the Brazilian Congress. Então, na época do governo Fernando Henrique Cardoso, houve a necessidade, após as privatizações, de, obviamente, adotar um modelo norte-americano de agências reguladoras, muito próximo ao modelo. A gente copiou praticamente o modelo todo, a gente só não tem o Administrative Law Judge, que é um juiz administrativo, e umas outras considerações, mas basicamente o modelo foi muito próximo ao sistema norte-americano, que visava isso, né, garantir maior segurança jurídica para os investidores, né, se adaptar a todas as pressões dos organismos internacionais, e isso aconteceu em boa parte do mundo. As of now, Brazil has 11 independent regulatory commissions in relevant industrial and infrastructure utility sectors. To mention a few, oil and gas, electric power, transportation, telecom, and mining. In addition, the Brazilian Central Bank is an independent agency, as are the Independent Commissions to Regulate Trade, que é o nosso CAD, Securities Exchange, que é a nossa CVM, Nuclear Security, que é a Agência Nacional de Segurança Nuclear, as well as Data Protection and Private, que é a nossa Autoridade Nacional de Proteção de Dados. As I mentioned, the Brazilian agency model was a partial reproduction of the American administrative state, bringing some novelties to local administrative law. Despite some opponents in the academia, in Congress, and the executive branch, the Brazilian regulatory landscape has been kept with the support of the Supreme Court. Looking toward the constitutionality of the Brazilian agency model, the Supreme Court validated the tenure system, the authority to administrative agents to promulgate rules with mention to the so-called intelligible principles, and the decision-making autonomy. Contrariamente a muitas pressões, não, do Congresso, do próprio Executivo, na mudança de governo, da própria academia, né, que existe uma parcela ainda considerável de doutrinadores ainda que são contrários ao modelo de regulação descentralizado, o Supremo Tribunal Federal confirmou a constitucionalidade do modelo, mantendo o mandato fixo, né, que eu falei aqui do tenure, a função normativa das agências e a sua própria estrutura. Therefore, in some but not many cases, the Brazilian Supreme Court has adopted the Chevron doctrine, which requires courts to defer to an agency's reasonable interpretation of a federal statute. I'd like to be clear, Professor Matthew, it has not deferred under the doctrine two steps. They mention the Chevron doctrine, but they not use the two steps like the US Supreme Court does. The Chevron doctrine, the most famous doctrine in all of administrative law, was named after the Supreme Court's 1984 opinion in Chevron versus Natural Resource Defense Council, upholding a regulation issued by the Environmental Protection Agency. Essa decisão que eles chamam de Chevron é um caso, né, que eles chamam de Chevron deference, ou seja, a deferência que o caso provocou e criou uma jurisprudência, vamos dizer assim, que deve ser seguida pelas cortes inferiores. Ele foi um caso julgado contra uma situação da Agência Nacional de Meio Ambiente lá, né, que é a EPA. The Chevron doctrine says a court is always to proceed in two steps. That's step one. If the court finds Congress provide a clear or ambiguous answer to the meaning of the statute, the court must enforce the understanding. São duas fases que eles aplicam lá, né? A primeira, que eles chamam de step one, eles vão verificar se a legislação é clara ou se ela não tem dúvidas. Se não tiver dúvidas, for clara, ela tem que ser aplicada. Applying step 2, if the statute does not provide a clear answer, ou seja, aplicando a segunda fase, se a lei não for clara, se ela for ambígua ou silenciosa, ou seja, se ela não for clara, if it is ambiguous or silent, the court is to enforce the agency's interpretation if it's reasonable. Ou seja, se a agência proferir uma decisão que seja razoável pelo olhar da corte, a corte então vai confirmar aquela decisão, ela não vai alterar aquela decisão, ela vai fazer, então vai ter a deferência com a agência e vai ser mantida a decisão da agência. So, I'd like to end my presentation pointing out that, first, Brazil has been partly adopted the US regulatory model since the 90s. Second, the Brazilian Supreme Court has been applying in some way the Chevron deference. Third, even though Chevron deference is still alive, the US Supreme Court has declared in a number of decisions that if an agency seeks to decide an issue of major national significance, its actions must be supported by clear congressional authorization. This understanding is known in the United States as the Major Questions Doctrine. Eu estou fechando, então, a minha apresentação fazendo esse resumo que eu já apresentei aqui e dizendo que, nesse momento, a Suprema Corte ela está adotando, em algumas situações, que vão ser, inclusive, julgadas agora em definitivo, a ideia de Major Questions Doctrine, ou seja, quando você tiver determinadas situações muito complexas, não se aplicaria a Chevron deference. Isso é que o professor Massel vai explicar. So, here I'm eager to learn from Professor Massel talk about the US Supreme Court recent trends, about the administrative state, and my Brazilian colleagues about possible impact in the Brazilian Supreme Court Judicial Review in regard to the regulatory agency. Estou fechando minha apresentação dizendo, então, que agora nós vamos aprender com o professor Massel, ouvir dele essa explicação sobre o que está acontecendo nos Estados Unidos e ouvir os meus colegas também, que depois vão fazer provocações ao professor Massel sobre essa mudança e, eventualmente, se isso vai trazer algum impacto para o nosso modelo regulatório, por aquilo que foi julgado pelo Supremo Tribunal Federal. Muito obrigado.
Do I need to use the microphone?
Yes, you can.
Do I need to?
No, I don't.
I don't need to use it. Great. I'm pretty loud. Can you guys hear me in the back? Yeah? All right. No one's ever complained that I speak too quietly. So, hi everyone. It's great to be back. I see some familiar faces. I was here a few months ago for another event on a completely different topic, and at that time I didn't realize that I'd have the wonderful opportunity to return so soon. So I'm just really, really delighted to be able to return. I want to thank the Rio State Attorney's Office and FGV for inviting me and for hosting me. I want to thank all of you for taking time out of what I know are extremely busy schedules with very important work and very important responsibilities to come to this event today. I'm going to start out this presentation in English, and then I'm going to continue in English and finish in English because it's the only language that I know. So I hope that everyone will be able to follow along well enough. Let's get right into it. So I've been asked to speak today about recent trends in the United States Supreme Court's doctrine on administrative law issues, focusing in particular on something that Sergio emphasized in his remarks on the so-called Chevron doctrine, or more broadly, the way courts approach review of an administrative agency's interpretation of the statutory authority that the agency is obligated with implementing. So I want to obviously address the most recent developments in the doctrine. Some of them are happening right now. In fact, the law may have already changed in a very significant way, and we just don't know it yet because the opinion hasn't been formally announced. We'll find out soon. But I think to understand the significance of the recent changes, it's important to understand the way things have been for the last many decades. So I know that it's actually been quite striking to me that many people in Brazil, at least in groups like this, are already very familiar with American legal doctrines like Chevron, for example, much more familiar than your average American lawyers are with Brazilian doctrines. It's a little bit embarrassing. So some of what I'm going to say may already be quite familiar to many of you, but please bear with me because I think it's important to get this basic groundwork clear to understand how and why the Supreme Court, U.S. Supreme Court, may right now be making some quite big changes to the doctrine. So this issue involves both an issue of constitutional law or constitutional interpretation and also an issue of the framework used to resolve issues of statutory interpretation. So I'm going to first talk about the relevant line of constitutional doctrine. Then I'm going to talk about the current approach to statutory interpretation issues. Then the next part of my talk, sort of the heart of it, I'll talk about how these issues have been changing, what the recent trends are. And then finally, I'll conclude by just saying a few words about what might come next, what direction we might be going, both doctrinally and also in terms of practical consequences. So, starting on the constitutional side, the United States Constitution allocates legislative power to the United States Congress, which it exercises through a constitutionally specified procedure. It involves passing legislation through both chambers of the United States Congress, our House of Representatives and Senate, and then presenting any bill that passes both chambers to the president for a signature or potentially a veto. Now, many of the statutes that are passed through the United States legislative process, and here the United States is not alone, I think Brazil and many other countries are similar, many of those statutes don't actually fully specify all of the rules and obligations and whatnot that people in the world have to follow. Very often those statutes empower agencies or departments within the executive branch of government to produce more detailed rules, regulations, decisions, orders, and so forth to implement quite general statutory instructions. So, for example, an environmental protection statute may say that the U.S. Environmental Protection Agency should establish, let's say, air quality standards or water quality standards that shall be adequate to protect human health and the environment. But the statute doesn't say exactly how many parts per million of sulfur dioxide can be in the air, for example. Or the statute might empower an agency like the Food and Drug Administration to set rules for the safe handling and processing of meat products or other food products, but doesn't say what those rules are. It just says there should be some, and the agency should decide on them. So there's a long-standing debate in American constitutional law about whether or under what conditions that's allowed. There's an argument that these kinds of statutes that empower executive branch agencies or departments to make more specific rules and regulations effect an unconstitutional delegation of Congress's legislative power to entities within the executive branch. There's also an argument that that either such delegations are completely consistent with the Constitution or that these statutes are not properly understood of as genuinely delegations. So this is, again, a long-standing debate in United States constitutional law. May Congress delegate, or at least authorize, regulatory policymaking, or what really looks like lawmaking, by the executive branch of government? So there's an official answer to this question and a real answer to this question. May Congress delegate to administrative agencies? The official answer is no. The real answer is yes. So in earlier cases, in the early 20th century, drawing on cases from previous periods, the United States Supreme Court said definitively, the legislative power is vested in the United States Congress and may not be delegated to the executive branch. However, the court also said that as long as the statute that empowers an executive agency or commission to act contains a sufficiently intelligible principle to guide the agency's action, then it's not actually an impermissible delegation to the agency, and therefore it's okay. So what does intelligible principle mean? How clear or specific does it have to be? The traditional answer for nearly a century now is not very clear and not very specific. A statute can say, for example, to the Federal Communications Commission, when you grant broadcasting licenses, do so, make those decisions to advance the public interest, convenience, and necessity. That's pretty open-ended, but the courts have said that's okay. That's not an impermissible delegation because that general guidance, public interest, convenience, and necessity, satisfies the very low bar of the intelligible principle standard. So again, the official U.S. constitutional doctrine, which has not changed or been overruled, is that our Constitution does not permit Congress to transfer its legislative power to the executive branch, but in practice, the test for finding an impermissible delegation is so easy to satisfy that for, again, nearly a century, really longer than a century, Congress has been enacting statutes that for all intents and purposes delegate lawmaking authority to administrative agencies. All right. So that's important. That's the first piece of important backdrop. We live in a world, United States citizens live in a world where pervasive delegation of lawmaking authority to administrative agencies is a central feature of how our government operates. Now, when these administrative agencies do things, when they exercise the authority that has been delegated to them under statute, oftentimes people are upset. Right? So in the context of an environmental statute, if the EPA sets a very stringent, let's say, pollution emission standard, industry groups will be very unhappy about this. If they set a relatively lax emissions standard, environmental groups or others might be very upset about it. So administrative agencies in my country get sued all the time. I suspect that probably happens here as well. Whenever an agency does something important, someone's angry about it, and when they're angry about it, they go to court. There are a whole range of legal arguments, as of course you know, because I'm sure it's the same in Brazil, that an aggrieved party can launch against an agency's decision. They didn't follow the proper procedures, they behaved irrationally, this, that, and the other thing. One important line of attack is that the agency's regulation or order is inconsistent with the statute that authorizes the agency to issue that regulation or order. Right? So oftentimes courts are called on to decide whether an agency has correctly or incorrectly interpreted its underlying statutory authority. Right? Is it, to use a sports metaphor, in the US I would say basketball, here I might say football, your football, is it in bounds or out of bounds if the statute defines the playing field, if you will. So there are a number of different approaches that courts can take to this kind of an issue. Again, I'm sure this is familiar to all of you. You can decide the issue. We would use the Latin phrase de novo. That is, the court just decides what the statute means. The court is the referee. It decides if you're in bounds or out of bounds. You can give some special respect or deference to the agency's view, but based on a variety of factors, a kind of case-by-case basis about whether the agency's view ought to be specially persuasive. You can have a more categorical rule of deference. And that's, to pick up on what Sergio was talking about, that's really the upshot of the Supreme Court's 1984 decision in the Chevron versus Natural Resources Defense Council case. That case, and here I'm just repeating Sergio, said that when a challenger argues that an agency has misconstrued its statute and the agency defends on the grounds that its interpretation is correct or permissible, the court, instead of deciding what the court thinks is the best interpretation of the statute, should ask, first, is the statute clear on this point? Does the statute clearly address and clearly answer the precise question at issue? If the answer to that is no, then as long as the agency's resolution of that statutory ambiguity is reasonable, the court should accept it or uphold it, even if the court would have been inclined to interpret the statute differently. It might help, many of you are familiar with Chevron, but it might help just to fix ideas to remind you the specific legal dispute in Chevron itself. Simplifying a bit, it was another environmental case. It dealt with some important pollution control measures that had to be adopted at sources, stationary sources of air pollutant. Well, what is a source of air pollution? Suppose you have a factory with many different pieces of equipment. You're manufacturing whatever it is you're manufacturing, but there are many different parts of the production process, so there are many different smokestacks, let's say. Is each individual smokestack a separate source of pollution, or can you say the entire factory consists of one and only one source? So again, if you have a factory with 6 smokestacks, is that 6 sources of pollution or 1 source of pollution? What the court said in Chevron is the Clean Air Act, the relevant statute, doesn't say one way or the other. It's ambiguous on this point. Congress did not express a clear view about whether a source had to be each individual smokestack or whether it could be a whole factory. So then it's the agency's choice. Whichever view the agency thinks is the better one, the agency can adopt, and the agency can change it. If 5 years from now or 10 years from now, the agency revisits that same issue, they can reverse their earlier decision. Why? Well, sounding themes that I suspect will be familiar, the court said, among other things, the agency has more expertise. Oftentimes, technical expertise or experience will bear on this. If the law isn't really clear, we should allow the decision to be made by the more expert branch. Also, the agency is more politically accountable than are the courts of appeal. So if Congress hasn't made a clear enough decision on this important issue, we should go with the next more democratically accountable branch of government, and that would be the agencies, because even though the EPA is itself not subject to democratic elections, it's part of an administration headed by a president who is. But, and this is a piece of the Chevron doctrine that in my encounters with people are familiar with it. Many people know that part of the doctrine, but they're not necessarily as familiar with the underlying legal theory about why it's okay. Because I know from conversations with Brazilian friends in Brazil, there's this principle of legality, right? Agencies need to act in a way that is legal. The United States has the same principle. And this question arises, it goes by different names, but many people would say, how can Chevron possibly be acceptable? Because one of the most famous sentences of all of American law, Chief Justice Marshall's opinion in the Marbury versus Madison case, he wrote, it's emphatically the province and duty of the judicial department to say what the law is. And doesn't Chevron say it's actually the prerogative of the executive branch to say what the law is? Maybe the agency has more expertise, maybe it's more politically accountable, but why does that matter? If it's an issue of law, if it's an issue of statutory meaning, shouldn't the court decide? So Chevron itself indicated or suggested an answer to this question that subsequent cases and commentaries have really developed into the underlying theory of Chevron, the theory of judicial deference, why judicial deference to an agency view about the meaning of a statute is not inconsistent with what you might refer to as the principle of legality. And this connects, there's a reason I started out talking about the non-delegation constitutional issue because it becomes relevant here. The theory goes like this. When Congress has written a statute that is unclear on some point, like what is a source mean, the court will construe that statute as if it is a delegation to the agency to decide among the permissible readings of that ambiguous word or phrase. To try to make this a little bit clearer, again, using the Chevron case itself as an example, if Congress had written the Clean Air Act to say, these pollution control requirements apply to a source, And a source can mean either each individual smokestack or an entire facility, and the EPA may, in its discretion, decide which of these two approaches is better. Under the non-delegation doctrine as it exists now, that would clearly be permissible. Congress would be allowed to delegate to the Environmental Protection Agency the decision whether to treat each smokestack as a source or to treat an entire factory as a source. Well, the reasoning goes, if Congress can delegate explicitly like that, Congress can also delegate implicitly. And the court will just will presume that an ambiguous statute is and should be treated as a delegation to the agency. So on this theory, it is not a violation of the principle of legality to defer to the agency's resolution of the statutory ambiguity, because the court has decided what the statute means. The court has decided that what the statute means is we delegate this choice to the agency. And then it's treated as a policy choice, not merely a legal choice. Now, did the court do this because it thought that Congress actually intended vague or ambiguous statutory provisions to be delegations to the agency? Probably not. And the court in Chevron doesn't make any pretense of trying to figure out why Congress really left the ambiguity in the statute. Rather, the so-called Chevron doctrine or Chevron deference is grounded in a legal presumption, a kind of legal fiction, not that different from other principles of law that are certainly familiar in the American system and I suspect are familiar in the Brazilian system as well. So, for instance, what we would call the rule of lenity, which I suspect has a different name here, is the principle that ambiguities in criminal statutes should be resolved in favor of the criminal defendant. Many of you are prosecutors, you're probably familiar with this. That's not because, usually, at least in America, that's not because we think the legislature actually wants to legislate really narrowly because it really wants to protect criminal defendants. It's because there are policy reasons justifying a rule of construction, saying to courts, when you're not sure, assume this is what the legislature meant, not because we think they really meant it, but because that assumption, that presumption serves other interests. So Chevron is similar. The idea is that, well, it's better if the more expert, more politically accountable decision maker, the agency, make these decisions if Congress hasn't been clear. So if Congress hasn't been clear, we will presume that that ambiguity is really a delegation. We will construe the ambiguity as if it is a delegation. So Chevron you can think of as a kind of pro-delegation, favorable to delegation, canon or maxim of statutory construction. Okay. So Chevron has been around for 40 years. It may not be around much longer. And that brings me to the next thing I wanted to talk about, which are trends in the U.S. Supreme Court in the development of this line of doctrine. The story actually starts earlier. I'm going to focus mainly on developments within the last 3 or 4 years, but I want to emphasize that not long after Chevron itself was decided, people, and occasionally courts, raised questions about the sweep of Chevron's broad idea that a statutory ambiguity should be construed legally as if it were a delegation by Congress to the executive branch. Let me give you a sort of series of examples of places where people have sought to narrow the domain of the Chevron decision and how that connects to the underlying theory of Chevron. More than 20 years ago, the Supreme Court, the U.S. Supreme Court, decided an important case called United States versus Meade Corporation, which suggested that Chevron shouldn't apply in certain cases where it would be implausible to suppose that Congress would have delegated the particular kind of interpretive question at issue to that particular kind of executive branch official. What the court emphasized in that case is, well, some agency decisions that interpret statutes are issued in relatively formal contexts, rulemaking proceedings with a lot of notice to the public, opportunity for public participation, opportunity for contestation. But in other settings, agencies make announcements about what they think statutes mean in letters that the agency or agency officials just issue without very much process at all. Sometimes those letters or guidance documents, in fact, are issued by relatively low-level officials in the agency. And so the United States Supreme Court in Meade suggested, well, in the former case where there's a lot of process, it makes sense to construe a statutory ambiguity as a delegation to the agency. But in the latter set of cases, it doesn't. So Chevron and Chevron's deferential doctrine ought not to apply in that latter set of cases. This decision prompted some people to say that in addition to the Chevron's famous two steps that Sergio talked about, Chevron was framed as a two-step inquiry, there's actually a hidden step zero of the Chevron inquiry where the court first has to decide, is this the kind of administrative interpretation of a statute that is worthy of Chevron deference at all, where that assumption that ambiguity equals delegation makes sense. Now, a second important area that Sergio mentioned near the end of his talk where we've seen a potentially important change in the doctrine is the emergence of something that has now been labeled the major questions doctrine. So what does that mean? Well, to get there, I think it's important to emphasize there have also been indications of some changes in the current Supreme Court's thinking about the non-delegation doctrine that I described earlier. So again, for a very long time, the assumption has been that even though officially there's a non-delegation doctrine of constitutional law, the intelligible principle standard or doctrinal test is so weak, so easy to satisfy, that basically delegation is okay. There are several justices in the current Supreme Court who think that's incorrect and want to revive a more robust non-delegation doctrine that would more strictly limit Congress's ability to authorize administrative agencies to make legal regulations or legal rules pursuant to very broad grants of statutory authority. They haven't gotten the votes yet to revive, to bring back from the dead the constitutional non-delegation doctrine. But that skepticism of delegation, that hostility to delegation, is manifesting itself in other ways, including limits on and now reconsideration of the Chevron doctrine itself. Because as I said earlier, Chevron is a pro-delegation maxim of statutory interpretation. When in doubt, assume Congress meant to delegate. If you're hostile to delegation, if you think Congress delegates too much and too broadly, and that this creates constitutional separation of powers problems, you would also be uncomfortable with an interpretive maxim that says treat uncertainty as if it is delegation. The major questions doctrine is an illustration of this idea at work. So, in several recent cases, the United States Supreme Court has considered issues where an administrative agency, part of the executive branch of government, has taken a statute and found a provision in that statute that the agency has read aggressively, broadly, but at least arguably in a plausible, linguistically, textually plausible way to take bold new regulatory action that people kind of hadn't thought of doing before under that statute. So, for example, there was an attempt by the Biden administration to invoke a piece of a public health statute to extend a moratorium on evicting renters during the COVID-19 pandemic. There was another attempt by the Obama administration to use a provision in the Clean Air Act that had not been used very much, but that seemed to authorize regulation of certain kinds of pollutants that were not covered by other sections of the Act, to adopt an aggressive regulatory scheme for regulating greenhouse gases from fossil fuel plants. And then the Biden administration also announced a plan to forgive U.S. student loan borrowers to forgive their loans under a provision of a statute that allowed certain kinds of loan forgiveness in times of war or national emergency. So, in all of these cases, the Supreme Court rejected the executive branch's assertion of authority. In none of these cases did the Supreme Court majority even mention Chevron. Not they raised Chevron and then said it doesn't apply. They didn't even talk about it. Instead, the Supreme Court did not say that the agency's interpretation of the statute was wrong or a less good interpretation of the challengers. The court said, when an issue is of major importance, major national significance, they use some different verbal formulations, we will not lightly presume that Congress meant to delegate such a big and important issue to the agency unless Congress has said so clearly and explicitly. And the Clean Air Act doesn't clearly and explicitly authorize the Environmental Protection Agency to regulate electricity markets as pervasively as the EPA had tried to do. The statute on public health doesn't clearly and explicitly authorize something like a moratorium on evictions, and the statute on emergency forgiveness of student loans doesn't clearly and explicitly authorize a categorical across-the-board loan forgiveness program, without making individualized determinations that someone was particularly affected. The Supreme Court said, we're going to have a presumption against delegation. We're only going to find delegation on these important questions if the statute is really clear. Now, what counts as a major important question? We're not sure. This is still being worked out. What counts as sufficiently clear authorization to allow an agency to regulate on a major question? This isn't clear. We're still working this out. There are a lot of questions, some might even say major questions, that flow from this so-called major questions doctrine. I want to highlight how the current version of the major questions doctrine, though it has roots in some earlier cases that the court cited that emerged during the Chevron era, is not only doesn't seem to be incorporated to the Chevron doctrine, it's the precise opposite. Right? Chevron said treat uncertainty as if it's delegation. The major questions doctrine seems to say treat uncertainty as if it's not delegation. So these doctrines are in deep, perhaps irreconcilable tension, at least unless you really restrict the major questions doctrine to certain kinds of special cases. But that brings me to the third and final thing I wanted to say in terms of trends in the doctrine. Chevron itself may be overruled soon. In fact, Chevron itself may already have been overruled. We just don't know it yet, because the Supreme Court heard oral argument about 3 months ago in a pair of cases, the Loper-Bright case and the Relentless case, which are the same case. I mean, they involve the same underlying issues. And the sole question that the court agreed to hear about in these cases is whether Chevron should be overturned. And based on the oral argument, it looks extremely likely that Chevron will be overturned. Even if it's not overturned, it will be dramatically narrowed. So again, the court has already voted on this, and the opinion is being written, so it's possible Chevron has already been overruled, and we'll just find out about it soon. From the arguments against Chevron, the oral argument and the briefs that were filed, it seems quite clear that many people, including I think at least 5, maybe more justices of the Supreme Court, are now deeply uncomfortable with this foundational idea of Chevron that courts can and should treat a statutory ambiguity as if it is a delegation. So partly because of hostility to delegation itself, it seems the current Supreme Court is much more inclined to the opposite kind of presumption, that we should avoid reading statutes to delegate authority, at least broad or important authority, to administrative agencies. And this principle of legality idea is really making a comeback, right? So again, Chevron and its defenders thought that they'd resolved the legality problem by explaining Chevron is in no way inconsistent with the principle of legality, with the principle that courts determine what statutes mean, because Chevron calls on courts to determine what statutes mean. This court determines either the statute clearly speaks to this issue, or what the statute means is that the issue has been delegated to the agency. But it now seems like, despite that having been kind of the doctrine for 40 years, the current Supreme Court is not comfortable with it. So, I've talked for longer than I meant to, so let me just say very quickly a few words by way of what might happen next. I think that might also come up in our open conversation that's going to happen in just a second. So, it's possible that the so-called non-delegation doctrine of constitutional law will be revived by the current court. There was a case a few years ago, about 3 or 4 years ago, called Gundy versus the United States, where Justice Gorsuch wrote a dissenting opinion calling for the revival of a robust constitutional limit on Congress's ability to delegate. He didn't have the votes then, but the court personnel has changed since then. Now, the court hasn't done it yet, but many people think it's more likely now than it has been in 80 years. Even if the court doesn't do that, it certainly seems that Chevron will be, if not either outright overruled or narrowed substantially, with an emphasis that courts really need to aggressively themselves determine statutory meaning and only revert to deferring to the agency if the statute's really so unclear they've got no idea, or if the statute uses very open-ended terms like reasonable or substantial, which might imply a kind of judgment by the implementer. It does raise the question of what comes next. Even if Chevron is overruled, what will the court replace it with? Right? Will we establish a regime of de novo review where the courts decide that they're the only final word on the meaning of statutes? Will we go back to the multi-factor, case-by-case determination of how much deference is appropriate under the particular circumstance of this case? Will the court do something else? We don't know. In terms of practical consequences, I would say that this shift away from a doctrine that is very comfortable with delegation and indeed treats statutory ambiguities as if they are delegations, to a new mentality that is quite skeptical of delegation and much less likely to accept an agency's aggressive stretching of its statutory authority. I think two main consequences flow from this that are related. One is there's a shift of power from the executive branch to the judicial branch. Right? There's a question about how much power gets shifted back to Congress. Defenders of the major questions doctrine, opponents of Chevron, say this will also shift power away from the executive back to Congress where it belongs as our primary lawmaking branch. Others say no, in fact, this isn't a shift of power to Congress, it's a shift of power to courts. Whatever you think is happening with Congress, clearly there's going to be a shift of interpretive authority and interpretive power away from the executive branch and towards the judiciary. Some people think this is a great and healthy thing. Other people think this is an unwise, maybe even dangerous thing. That's the debate that rages on. But in terms of how it affects the allocation of power, that seems pretty clear. The other thing that will happen, and I think this is related, is this will introduce even more of what you might call a status quo bias, or some might say a libertarian bias, into the United States lawmaking system. So, as many of you probably know, the U.S. system is fragmented formally and extremely polarized politically. And there are all sorts of mechanisms, some of which are in the Constitution, but some of which are not in the Constitution, like the filibuster, that make it extraordinarily difficult to pass major legislation on anything significant and controversial. You know, COVID response policy, climate change, immigration, you name it, nothing big is going to move through the current Congress. Now, for quite a while, what many administrations had done in the face of congressional inaction was to try to use existing statutory authority aggressively to accomplish their goals. So the Congress is not going to pass comprehensive climate change legislation. So the Obama administration says, we think we already have the authority under the Clean Air Act to make substantial progress on this issue. President Biden really would like a national vaccine mandate for COVID. Not going to happen. But the Biden administration, the Center for Disease Control, thinks that under existing statutory authority and the Occupational Safety and Health Administration, that they can do something like that. The court has made it clear it doesn't like this anymore. Really made it clear it really doesn't like when the executive branch tries aggressively to find old statutes that can be used in creative ways to address new problems. What that means, given polarization and fragmentation in the U.S. lawmaking system, is that not very much is going to happen on big issues. Basically, the use of executive power coupled with the Chevron doctrine created a kind of workaround for gridlock or paralysis in the U.S. Congress. Now, again, whether this is a good thing or a bad thing depends on whom you ask. Some people will say, this is great. This is good because this returns things to the way they're supposed to be under the American constitutional system. It prevents an arrogation of excessive power to the presidency and the executive, which is then used to circumvent all of the checks and balances that the framers of the American Constitution built into the process. Others say this is a disaster because we've got a dysfunctional, polarized, ineffective Congress. Even if new statutory legislation would be the ideal, the second best is to allow the executive some flexibility to use the legal authority it already has to accomplish its goals. And moreover, this argument sometimes continues, the fact that the executive has at least some latitude to take big action unilaterally puts pressure on Congress to do something, because members of Congress who, let's say, don't want to do anything about climate change or immigration might be more likely to come to the negotiating table if they recognize that a complete intransigence could provoke unilateral executive action. So again, there's an important normative debate to be had about whether these trends in the U.S. Supreme Court administrative law doctrine are good or bad. But I think there's widespread agreement that they're quite significant, and they're significant in the directions that I just described. There's going to be a shifting of power from the executive to the judiciary, And related to that, there's going to be an increased difficulty in making any kind of major policy change at the federal level, at least when it comes to things like regulations as opposed to taxes or spending. I'm sorry for speaking longer than I intended, but I wanted to make sure I got that all clear. Let's now transition to the fun part where we get to hear from all the other experts up here. So thank you very much, everyone.
Professor Matthew Stephenson, thank you so much for your presentation. It's very helpful for us, to everyone, to understand better these trends. And it's allowed us to discuss the possible influence in Brazil. Thank you so much. And right now we are going to go to the next step with the comments from our colleagues, and after that, open for a Q&A. I will pass the floor to Professor Victor Aguiar.
Thank you, Professor Matthew. Thank you, Sérgio, for your outstanding presentations. I'm sure our audience learned a lot from you this afternoon. I think our mission here as debaters is trying to connect these topics with Brazilian law. And I think it's an important discussion because a few years ago, Professor Eduardo Jordão, you know him very well, he wrote a short article pointing out that nowadays American administrative law professors are among the most quoted professors in Brazil. For example, Cass Sunstein is the most quoted professor in Brazil. So there is a clear rise of American influence in our administrative law and the decline of the influence of Italian professors and also French professors. However, of course, Brazilian law, American law are not the same. Professor José Vicente, I'm not sure if he, I think he's also with dengue fever, Professor José Vicente. And he wrote an article a few days ago stating that, look, we have to take it easy with comparative law because jurisdictions are different. For example, there is a famous book in the US entitled, Is Administrative Law Unlawful? And it makes sense in the American way of thinking about administrative law. Oh, it doesn't make sense, not even there. Okay. Okay, not even there, it makes no sense. But here in Brazil, for sure, it doesn't make any sense because our administrative law is for sure lawful and it's even constitutional because it's not a constitution. Another example, the idea of administrative state. Many Brazilians write about, oh, administrative state, but the state in Brazil has always been administrative state, so it doesn't make much sense. Anyway, as Professor Sérgio explained here, I think our regulatory system is clearly based in the US, and we study and we quote Chevron a lot considering our independent agencies. But I'm curious to hear from you how Chevron is applied considering also the executive agencies. Because what I noticed here in Brazil is, despite the fact that we do not have a differential doctrine, our Supreme Court is different to most of the independent regulatory agency decisions. But considering executive agencies, there is very little difference. Courts in general understand they are entitled to apply de novo, to apply a de novo review and to decide out of scratch and apply the best interpretation of law to any kind of decision. So I'm curious about that, how it works in the US. And, well, what is your expectation now that you think you are convinced that Chevron is going to be overruled very quickly?
All right, maybe I'll
switch to the mic here since I'm sitting down and can't see everyone quite as well. So, as a formal doctrinal matter, it sounds like in contrast to Brazil, in the United States, the Chevron doctrine has applied to independent agencies and executive branch agencies in basically the same way. There's not a difference. Now, it wasn't immediately clear that that would be the case, but it became clear fairly quickly. And it's not like there was an extended discussion about this in any given Supreme Court case. They just kind of went ahead and applied Chevron. I should say, actually, in terms of terminology, this is a little bit of a side point, but it might be important. At least in the United States, the term independent agency can have a number of different meanings. Among administrative law professors or experts, it actually has a kind of specialized meaning. It means an agency whose leaders cannot be removed by the president during their term of office unless there's good cause, usually meaning malfeasance, neglect of duty, or inefficiency, and attempts to remove the head of an independent agency before the expiration of their term can be reviewed judicially. I mention this because people use the term independent agencies in other ways. So, for example, sometimes people in the United States, public administration professors or political science professors, for example, will use the term independent agency to describe agencies that are not part of any cabinet department. In Chevron, the agency at issue was the Environmental Protection Agency, which is not part of a cabinet department, but is not an independent agency in the sense that I just described. The administrator of the EPA can be removed by the president at any time without it showing good. There's a single head, exactly. Traditional independent agencies also in the United States are governed by multi-member commissions or boards. There's a whole other line of recent Supreme Court doctrine about whether Congress can create independent agencies with single heads. The answer is apparently now no, even though for many years people had assumed the answer would be probably yes. So that's not your question, but I wanted to make sure we clarify, because I think Brazil might use the terminology in perhaps a somewhat different way. But in the United States, we've got these independent agencies, we've got these executive branch agencies. Chevron applies, it's not dead yet as far as we know, in the same way to both of them. There were arguments among scholars, and occasionally others, that the deference doctrines ought to be different. So one line of argument is that Chevron ought to apply more, that is, deference should be more willingly granted to interpretive decisions by independent commissions rather than by executive branch agencies, on the logic that Congress would be more likely to delegate interpretive authority to an independent commission staffed by experts, let's say, rather than to a part of the executive branch headed by the president, who might be considered Congress's institutional rival. There was another line of argument that said, actually, Chevron makes a lot more sense for the executive branch agencies and less sense for the independent commissions. That argument focused on the piece of Chevron that emphasized political accountability as a reason to be more inclined to allow the agency to resolve a statutory ambiguity than a court. So if you think that executive branch agencies are more politically accountable precisely because they're subject to presidential control, and you think political accountability is one of the strongest and most persuasive justifications for having Chevron in the first place, then you might think that, well, when you're talking about an independent commission that doesn't have as much responsiveness to the president, then maybe you'd be less comfortable. So there were these debates, there were these arguments. The doctrinal answer to your question, though, is pretty straightforward, which is U.S. law has not drawn any such distinction. Now, if Chevron is indeed overturned, I think it will be interesting to see whether the agency's status as an executive branch agency or an independent commission starts to play in to the court's view of how much respect or attention the agency's view is due. I think the current Supreme Court doesn't like independent agencies. They've really been trying to cut back, so it wouldn't surprise me if Chevron is overruled, we then get subsequent decisions indicating that the court should be especially skeptical of interpretations advanced by independent commissions and maybe more indulgent in, if not actually deferential to, interpretations advanced by executive branch agencies, but that's pure speculation on my part.
Okay, thank you, Professor. Patrícia?
Thank you. We had lunch together, and we were chatting about some of the questions Professor Stephenson talked about today. But I am more interested in a kind of sociological view of the judiciary action. And I think this subject is, in a certain way, related to that sociological view of judiciary action. In Brazil, we have to understand how the judiciary power acts toward administration in regards to the 1998 Constitution and in regard what happened before. That is, in 1998, we were all very worried about executive expansionism. We had 40 years of, 40 years? I don't think so, 25 years of dictatorship in which laws and executive power had all the power. What happened in 1998 Constitution? 1998 Constitution emphasized judiciary power. All breach of law should be subject to judiciary review. In regard administrative power, political power, everything should be examined by judiciary power. And what we are watching in the last 35 years, and step by step, judiciary expansionism. And we not only don't have a deference theory, but we have a judiciary power that believes itself capable to examine all administrative actions. By exception, they recognize in time to time, well, here we can't go. So we are now worried here in how to bring the genius back to the bottle. We are now worried how we are going to put it back. And hearing you say, you are experiencing a shift that, well, you had 40 years of judiciary auto-restraint in a certain way, and now your genius is going out of the bottle. It's and the reflections I think we should make, and is as I'm hearing you say, will this major doctrine, major questions doctrine, will increase legislative power to act better? Because if it would be a result of this, well, we are pushing legislative to legislate better. That's the question. We have the problem. Legislative doesn't want to legislate. And in regard of administrative questions, even less. Legislative doesn't want to legislate. We could reflect, will this posture of judiciary power in a certain way pushing the legislative power to act better, to legislate better? I'm skeptical about that. I think you are as well. I don't think we'll have legislative power to act better, to have better laws, to have, I'm really skeptical. And what will happen, as you say, you will face a time of judiciary expansionism. Is it good? Well, we have this experience here. It is not good because it makes judiciary power a political actor. And I think it's what you're worried about. My question, do you feel if this happens, and it's happening, probably the Supreme Court and other inferior courts will accept and examine much more cases, many more cases involving administrative actions. Do you think it will expand, and how it, and to how in what extent it will expand judiciary review of administrative actions? Because as far as you can see at this point, American judiciary power has been very cautelous through time, and they examine only few cases regarding administrative action or interfere. Do you think it will expand enormously the number of cases and the number of decisions, and though expand judiciary power in regard of administrative action? I'm sorry about my terrible English.
That's an interesting question. So I think there are a couple of distinctions I'd want to try to draw in answering your question about whether these developments in American administrative law doctrine will increase the number of cases or the degree of judicial review over administrative action. So one distinction is between the cases that are decided by the United States Supreme Court and the cases that are decided by the U.S. federal judiciary overall. Another distinction is between the quantity of cases that are decided and the way those cases are decided. So I'm quite confident that if indeed Chevron is overturned, or even if it's not, just under the new developments in the major questions doctrine, there are going to be significant changes in judicial review of administrative action, and greater power shifted from the executive to the judiciary. The way you framed at least part of your question sounded like you're asking, will the U.S. Supreme Court be deciding quantitatively a much higher number of administrative law cases? I don't think so, or at least if there's a difference, I don't think it'll be that big. I don't think the difference, I don't think the impact of these doctrinal changes we're going to see is going to be primarily in the quantity of U.S. Supreme Court decisions. Most administrative law cases are decided at the lower levels anyway, at the Court of Appeals level. Our Supreme Court is, I think, different from your Supreme Court in terms of the caseload volume and the ease of getting a case to the Supreme Court. And the court is already hearing like the really big cases. So the major questions doctrine cases are the really big cases. It'll keep hearing those. There might be a bit of an increase because if Chevron goes, or now that the major questions doctrine exists, there's going to be some cases at the margin that a few years ago would have seemed so hopeless that a challenger wouldn't bother investing substantial resources in trying to bring them because it would seem pretty obvious they were going to lose. And now they might feel like they've got a shot, right? Because maybe with no Chevron, they might be able to persuade a court that, you know, their interpretation of the statutes are better. Maybe they can try to convince a court that it's a major question if it's right on the line. So I do think there will be some increase in the volume because, again, some cases that before in a system where litigation is mainly financed by private parties, they wouldn't have bothered because it would seem so obvious they would lose, and now maybe that would change a bit. So that might be offset though by cases before the agency was confident that it would win. The agency now is not nearly as aggressive in pushing its statutory authority. So this is actually really important. The biggest impact of these doctrines may be on the cases we never see. Right? After the major questions doctrine, the next time an administration is thinking, we really want to accomplish this goal, Congress won't pass a statute. What if we root around to find an old statute that might have some ambiguous authority that we could really stretch? Now someone in the agency lawyer's office or the president's lawyers are going to say, don't bother, we're going to take years doing this, and the Supreme Court's just going to say no. So in terms of the volume of cases, I actually think there'll be an equilibrium or it'll be about the same. But that doesn't mean the doctrines don't have a huge effect because, again, at the lower court level, what the courts are doing in these cases and the cases that then get brought, I think is going to change quite significantly, right? So again, especially if parties are able to engage in what we call forum shopping, right? Try to pick a jurisdiction with a judge that you think will be sympathetic to your cause, you're much more likely to be able to get a win on some issue that maybe before you thought, look, even let's say you're a right-wing organization, even a conservative judge will have to acknowledge that the statute here is sufficiently ambiguous that under Chevron, the court just has to defer to the agency. And now that Chevron's gone, you said, hey, if we can file in this district in Texas where we know we get a conservative judge, maybe we'll actually win. So I think that there will be substantial differences in what agencies do and what happens in the cases that get litigated. But I don't think, especially at the Supreme Court, they'll really show up in terms of numbers of cases.
Thank you, Professor. Thank you, Vitor. Thank you, Sérgio, Patrícia. It's a great pleasure, and I really liked your lecture. I learned a lot, and I think it was really make things easier for us to understand and very useful. And I know that I try to avoid some normative consequences of what's going to be decided, but I'll try to push you a little bit regarding some normative points. And I think Patrícia tried, but you also tried to skip this. And I see this whole problem as a separation of powers problem. You know, in Chevron in 1984, the question was, should we trust agencies? Should we trust Congress? Should we trust the judiciary? And they decided we should trust agencies. We should understand that when there is an ambiguity, and in most of cases we will agree there is an ambiguity, even if the agency is not, even if Congress is not clear about this ambiguity. So they, as a rule of thumb, they decided we should trust the executive branch, which is a very, it's a decision for me like. Which praises presidentialism. You know, if you have a presidential system, we should trust. At least the government has to lead. The president has to some way to lead the path of administration. And political, of course, and political accountability, because in a presidential system, you have this kind of accountability, so you have to trust what's going on there. Now, in 2024, it seems to have this shift of power. As I wrote the same thing that you just finished your. So, and courts, what courts are saying that is that we should not trust agencies that much. So now they are worried. And maybe, I don't know why they worried, and they are saying we should trust judges, because what we have here are questions of law, and since Marbury versus Madison, all questions of law should be addressed to the judiciary, and the judiciary is capable of deciding it. And my question to you, I actually will provoke you even more. Justice Scalia in 1989, he gave a very famous lecture in Duke Law School, I guess, and it was published later. And he finished his lecture with this phrase, which I will quote. He said, "I tend to think, however, that in the long run, Chevron will endure and be given its full scope, not so much because it represents a rule that is easier to follow and thus easier to predict, though that is true enough. But I think that was the reason, but he said, but because it more accurately reflects the reality of government, and thus more adequately, serves its needs." So what he's saying, Chevron serves governmental needs. I would like to hear from you, and connecting for the first question, should we trust judges? I would like to hear from you about this prediction made in 5 years later after Chevron. And do you believe Chevron does not reflect the reality of government anymore? That's the impression. And does not serve its needs anymore. So, and if it does not serve governmental needs anymore, we should shift to the judiciary. That's my provocation. That's thank you.
I don't think the needs of government have changed in any meaningful way. So I think what's changed is the attitude of the current justices of the Supreme Court towards Chevron, not any underlying change in the surrounding conditions. So
Let me stop you here. It changes the attitude from that justices have towards Chevron, but it seems to me that there's a shift from a conservative point of view to a more progressive point of view. That's what I want you to elaborate.
It's interesting. So you anticipated something I was going to get into, which I'll try to keep this all at a very high level in my remarks. I was talking about sort of theories and so forth, not talking about like crude, down in the mud partisan politics. But there's it's important to understand the partisan complexion of the Chevron doctrine. So, and the attitude of the conservative legal movement, to some extent, liberals or progressives, have changed a lot on this. So I'm going to get to your specific question, but let me try to frame this because I think it goes to this. So when Chevron was decided, among Chevron's most enthusiastic proponents were political conservatives, and among Chevron's sharpest critics were liberals or progressives. And the specific Chevron case might have something to do with that because Chevron involved a regulatory effort by President Reagan's Environmental Protection Agency to relax environmental standards by changing the interpretation that had been adopted by President Reagan's predecessor, President Carter's EPA. And so during the heyday of the Reagan administration, there was a sense that Chevron would liberate agencies like the EPA or the Occupational Safety and Health Administration or so forth to change course to follow the president's political agenda. And at that political moment in the United States, it appeared that the presidency would not always be controlled by members of our conservative party, the Republican Party, but quite frequently. President Reagan had won a decisive election campaign a few years later, I think after Chevron, but not long after. He decisively won re-election landslide. And at that point, the federal courts, including the Supreme Court, were thought to be not exactly progressive, but more left-leaning. So there's certainly a story at that point where people thought, and the United States Congress had been controlled by Democrats for decades, right? The Senate went Republican in the early 1980s, but then went Democrat again in the midterms. So one story that you can tell about this is that at the moment of decision, Chevron seemed like kind of a conservative doctrine. But then there was a long period of time, I would say from about, let's say 1990 to 2010. Let's say the 20-year period or so. I'm making up the numbers a little bit, but just close enough. There's a pretty broad-based, bipartisan Chevron consensus, or at least acceptance. There were still Chevron critics, both from the left and from the right, but it was not a particularly partisan issue. When I would teach my students this doctrine, when I learned this doctrine as a student, most students had never heard of it. And the debates about Chevron, whether it was good or not, did not have a particularly partisan political cast to them. It was very different from discussing in a law school class the Supreme Court's decisions on things like abortion or death penalty, where liberals and conservatives knew already where they should stand before they'd even read the case. Nobody thought about Chevron. It was this obscure administrative law doctrine. To connect this to Justice Scalia's quote that you read, a lot of people who would defend it thought this is just good for government. Like, it's just good for government to work this way. Chevron started to become a partisan issue around 2012. You can't date it exactly, but pretty close. So the first time ever that the Republican Party platform had in it language objecting, not to Chevron by name, but to the idea that courts were ceding too much power to the executive and they ought to restore the rule of law. That's when you start to see Republican members of Congress introduce legislation to overturn Chevron by statutes. So what's going on? Well, I don't want to be too crude about it because people can be thoughtful and come to these issues sort of philosophically through their own process of reasoning, but it's perhaps notable that at that point, President Obama had just been nominated for a second term and then cruised to re-election quite decisively. The federal courts were at that point much more conservative, right, because of 12 years of Ronald Reagan, George H.W. Bush, and then George W. Bush was very aggressive in appointing a lot of his people. He got several Supreme Court nominations. So a partisan story here is that the idea of shifting power from the courts to the executive branch looked really appealing to political conservatives in the 1980s. And the idea of shifting power from the executive branch to the judiciary looks really appealing to conservatives in the 2020s. Now, again, I don't want to be too crass and crude. I don't want to say that these guys are just like trying to calculate what doctrines will help their team. But I will say in terms of the intellectual culture, what arguments people start to take seriously and which ones get propagated, I do think the change in the partisan situation has an effect. Something else that's related here, for better or worse, I think that, again, when Chevron was initially decided, I think it was often associated with liberating more conservative administrations to deregulate or find ways around regulatory mandates. Presidents Clinton and Obama really figured out that if Congress was blocking their domestic policy initiatives, Chevron and associated doctrines made it more plausible for them to take aggressive left-wing domestic policy action without getting approval from Congress. So if I want to be a little bit more charitable to the political conservatives, you might argue that they started to get nervous about Chevron because those in the political left were, they might say, exploiting it. I'll put that in sort of scare quotes because I'm not sure I would use that terminology. That's also, by the way, I think one of the reasons that political liberals or progressives or people who were more inclined to experiment with new, bold regulatory action became increasingly enthusiastic about Chevron, even though back in the 1980s, in the wake of the decision, some of Chevron's harshest critics were on the political left. Because when you're living in a world where, given the US separation of powers system, most of the time, at least one of the House Senate presidency will be controlled by Republicans. And even when you get the trifecta, even when you get the Democrat in the White House and Democrats controlling both in the House and the Senate, it's going to be extremely unusual to get 60 senators, which is now the default requirement to get past what's called a filibuster in the Senate. President Obama had it briefly. He got to 60 votes just in time to get his signature health care law passed. But I think many people think, maybe not in our lifetimes are we going to, that's probably an exaggeration, but the chances of seeing one party control both houses of Congress, the presidency, and 60 votes in the Senate, very, very low. And so for people who wanted to significant climate change action or significant regulatory action for internet regulations, say net neutrality, all these things you're not going to get through Congress. So some people think that makes Chevron even more appealing, right? And politically, that means people on the left, people who are more progressive, are going to be enthusiastic about it. And people on the right are going to become increasingly skeptical of it because it looks like it's being exploited, you said, as a separation of powers issue, to do a kind of circumvention or end run around the safeguards that, from that perspective, are supposed to stop the federal government from doing big, bold regulatory action lest they can get sufficient consensus from everybody. So I do think there's a partisan story. I do think there's a political story. My initial answer to when you quoted Justice Scalia, and this is why I resisted it, I don't think the basic conditions of government have changed. Partisan alignments have changed. Whose interests are best served by this kind of doctrine has changed. Justice Scalia, though, was attempting, portrayed his piece not as writing for a particular moment, but as kind of for the ages. Like, this is just the way government works. Of course, agencies have to work out all this stuff in the course of implementing statutes, and courts shouldn't be second-guessing all of it. That would just be too disruptive. I think that interpreted that way, that hasn't changed, I don't think. It would be really interesting what Justice Scalia would say about the cases to overrule Chevron. I think he would oppose them. I think he would get around them by saying his aggressive approach to interpreting statutes based on their text meant he could often reach the results that he wanted while still preserving Chevron as a doctrine, especially to provide guidance to the lower courts. So I don't think he would have been on this team. And it's interesting because modern conservative jurists idolize Justice Scalia in many respects. Like, what would Justice Scalia have said about this issue? Not on this one. I think they're perfectly willing to part company with him on this one. Justice Thomas publicly declared that he'd changed his mind on this issue. right, like after the Republican Party basically changed its mind on the issue, Justice Thomas declared his own mind had changed. He'd written earlier opinions kind of robustly endorsing a strong version of the Chevron doctrine, talking about the importance of deferring to agencies. Back in 2005 was the last, I think, major Justice Thomas opinion that was like, yay Chevron, endorse Chevron, broaden Chevron, over a dissenting opinion by Justice Scalia that thought that the court had gone too far. But certainly after the 2012 reversal, not anymore.
Thank you, Professor. Let me ask you one more question, and then let's try to hear a question from our audience. I know you like to hear from them. We know, and you already talked about it, traditionally there used to be some kind of partisan balance among justices in the Supreme Court, but recently there is a clear conservative majority. And you are also a political scientist, right? You hold a PhD from Harvard as a political scientist. How do you see, as a law professor, as a political scientist, the way the Supreme Court works these days, its composition? We have been discussing that Supreme Court is trying to overturn some landmark cases, not only related to administrative law, but related to other subjects. And some relevant American scholars, I'm going to quote here Michael Klarmer from Harvard Law School. Michael Klarmer, for example, sustains, and he wrote about that the court should be packed. The Democratic Party should just pack the court because the court nowadays is completely disconnected from American society. How do you see this as a political scientist, as a law professor?
In terms of the diagnosis of what's going on, I think I'd basically agree with you and agree with Professor Klarman in the part of his piece you didn't quote. But I think the current Supreme Court is really conservative and really conservative. There are two senses of conservative. There's conservative in the sense of right-wing politically, and there's conservative in the sense of cautious, careful, not wanting big changes or big breaks. The current U.S. Supreme Court is conservative in the former sense and not at all conservative in the latter sense. Extremely aggressive, extremely disruptive. And the fact that for 12 years, under the last years of the Rehnquist court, the court was right-leaning. So the pivotal justices that year, the ones who were close to the center, were Justices Kennedy and Justice O'Connor, both of whom were Republican appointees, were generally conservative. But they were kind of moderate conservatives, and they also cared a lot about stability and non-disruption and didn't want to go too far too fast. And that meant on the big ticket cases, you got a lot of 5-4 opinions. More of them went in the right-wing direction, the left-wing direction, but not all of them. And they didn't tend to be hugely disruptive. They would often preserve, but maybe erode or modify precedents rather than throwing them over. So now, because of random chance, essentially, and maybe some mistakes about when to retire or not to retire, President Obama in 8 years got to appoint, I think, 2 justices, and President Trump in 4 years got to appoint 3. This is, and maneuvering in the Senate basically blocked President Obama from being able to fill a seat. Justice Ginsburg dying at an inopportune time. So basically what we have right now in the US is a 6-3 conservative supermajority, where very few of those conservatives are small c conservative in the sense of cautious. The closest to that might be Chief Justice Roberts on some issues, but not on others, not on administrative law issues. He's actually one of the more, I don't know, radical is the right term to use it, but he's not super cautious, super careful the way he is on other issues. So it's a far right court. It's a really aggressive, activist far right court. Doesn't seem to have much hesitance about overturning precedents that have been around for a long, long time if it doesn't like them. So is it out of touch with what most Americans think? Yeah, almost certainly. Should that matter? That's a hard normative debate. As I'm sure you know, there's a long-standing question about whether part of the court, how much court should follow public opinion, whether they should at all. But I think this court is like, it's a radical court politically, it's a radical court legally. I mean, it's embracing legal theories that, 10 years ago, even in conservative legal circles, would have been thought to be rather outlandish. Now, what to do about it? If you think it is a problem, and I do, I should be honest about that. Like, I don't want to give like a big political partisan speech here, but yeah, I think this is a problem. What to do about it? So the court packing idea, I mean, maybe it would be justified, maybe it wouldn't be justified. It's completely politically impossible and infeasible. I mean, so I'm not sure it's productive right now to make that the centerpiece. I think that, Democrats, our left-wing party, can and should run against the court in elections. Not literally, because their judges are not elected, but by same thing Republicans did, our right-wing party, for years and years and years and years, using the liberal judicial activists as the thing to mobilize people and turn out the vote. So much as our conservative party used the constitutionally recognized and protected right to abortion as a way to mobilize their voters to win elections and eventually replace the court, I think our left-wing party, the Democratic Party, is likely, they're already doing that, to try to mobilize voters, especially women and younger voters, to turn out, with anger to the Supreme Court. That doesn't do anything in the short term. That might be the political strategy. If I were advising a Democratic president or senator, and I'm not, they don't care what I think, but if I were, I don't think I would say really put like court packing front. And if don't call it court packing, whatever you do, but I don't think my political strategy would be to foreground that, because it seems like the odds of success are really low, and the odds of creating a backlash and allowing the other party to say you're like opposed to the rule of law and you're trying to undermine judicial independence and so forth, that's not great. If you got to a political moment where you actually got, a decisive enough Democrat coalition in the House, Senate, and White House, and it was the Supreme Court that was standing in your way, maybe then some of these things might start to be thinkable. But whether or not it would be normatively defensible to pack the court if you could, I tend to think that now and for the foreseeable future, it's so completely off the table in terms of political feasibility that I wouldn't foreground it. Now, again, one thing that scholars, and this, I want to make clear that part of what Professor Klarman may be doing, what others may be doing, is normalizing something that now seems outlandish. So in the short term, you couldn't do it. But if you get more and more respectable law professors talking about it in a serious way, talking about curtailing the court's power in a serious way, theories that today seem just so crazy no one would take them seriously start to become thinkable. And if they start to become thinkable, members of the Supreme Court might start to worry a little bit more about this and might have some incentives to be a little bit more cautious about not going too far. But this is all medium or long or very long term. I think in the short term, we kind of have to live with it and try to win elections.
Can I ask something more? You said that they are we have now in the United States, you have a very aggressive, conservative in an aggressive way, the conservative that wants to change everything, And is it possible to consider, I don't know, maybe it's a black letter law, and I'm sorry if I don't know it. If Chevron is overruled, it would be possible to relitigate cases which were decided according to Chevron?
Yeah, I don't know. So one of the things that's going to happen if the court overrules Chevron is they're going to create just waves of new litigation about all the unresolved issues in Chevron's wake, and you've put your finger on one of them. So I just don't know. So one possibility is to say no, because stare decisis for interpreting the meaning of a statute is typically considered even stronger than stare decisis on other issues. So one thing you could say as well, the case where the court, Chevron itself, what the court did in Chevron is it interpreted the Clean Air Act to delegate to the EPA this choice regarding the meaning of source. And if the court has determined that that's what the statute means, then that's what the statute means, and it just does, even if in another case the court wouldn't apply Chevron. Another possibility is to say, no, the court deferred to the EPA because it was invoking a maxim of statutory interpretation that doesn't exist anymore. So if the same issue came up again, the court would decide the issue in the absence of that maxim of interpretation and do something differently. I don't know. I think they don't know. I think they haven't thought that far ahead. I think they're so caught up. I'm editorializing a little bit now. I think they're so caught up in this fervor of like, we're going to tear down this terrible decision, and this will like rein in these crazy Democrats who are doing these crazy things, and will empower, us to decide more of these issues. I think there are going to be, scores of subsidiary issues that we haven't even thought about yet that are going to now come up. And by the way, this is not the Chevron issue, but to connect this to the court's decision in Dobbs, which overturned Roe versus Wade, I think the stupidest line in all of the Dobbs opinions comes from Justice Kavanaugh, who I don't think is a stupid person. I think whatever else you think about him, he's an extremely intelligent person. But he said in his Dobbs concurrence, basically, I'm paraphrasing here, I don't remember the exact line, now we're done, we being the federal courts. Now, at long last, the federal courts can get out of the abortion issue, and we'll leave it where it belongs with the people's elected representatives. Not so, right? Because now there's like case after case after case trying to figure out in the wake of Dobbs what happens with all this whole range of issues. What about FDA approvals of abortion medications? What about states that pass laws on the assumption that abortion was constitutionally protected, but now it's not anymore? Do those laws go back into effect? Do they not? Like, we're just going to see. And so whatever you think about the Dobbs opinion, the idea that that opinion would get the federal courts out of the business of addressing abortion cases was just, I don't know how we could possibly think that was true. So too with Chevron. If and when they overturn it, that won't be the end, because we're going to be litigating for years and years about what comes after Chevron and what we do with all the cases that were decided before Chevron. And different courts of appeals are going to come to different interpretations. The Supreme Court's going to have to take more of these cases and try to figure it out and provide some guidance, and who knows what's going to happen.
Once you free the genius out of the bottle, you don't know what the genius will be capable of doing, and we don't control the consequences of freeing the genius out of the bottle. That's the problem. In Brazil, Brazilian Supreme Court in 2022 had ruled a case. Some political party argued in the Supreme Court if a presidential decree regarding data protection from government, and they argued that this presidential decree was unconstitutional. And the Supreme Court not only recognized the unconstitutionality of the presidential decree, but what made me, it said, well, for some kind of decree to be constitutional, it should contain what happened. The Supreme Court ruled the subject. It's not it didn't say, well, it's a legislative question. No, they ruled what it would be necessary for a presidential decree to be constitutional. What happened? The president issued a new decree incorporating all the rules made by the Supreme Court. And that's what's happened when you free the genius, the judiciary power, bound no limits. Well.
Yeah, sure. I don't have anything else to do tonight, so I'm happy to stay here as long as you guys want.
So we had a very qualified audience here. Rodrigo, Perry, many state attorneys, Rafaela was on Flag. I'm not sure what else. Now it's working, right? Obrigado. Rafaela was my classmate, my master's degree. My advisor, master advisor, was here. Now he has just left. He's a full professor of administrative law at the State University. Anyway, anyone would like to ask a question? Oh, you again.
Thank you, Professor Stephenson. I would like to ask a question regarding with the probable overruling of Chevron. You will be transferring power from a unified authority, the federal government, the federal executive, to a very fragmented authority, which are the courts. So I suppose that this creates the risk that federal statutes will be applied very differently in some areas in some states or under some circuit courts than in others. And I would like to know, are there mechanisms for overcoming these contradictions, or will the Supreme Court have to intervene in every such case?
Yeah, basically the Supreme Court will need to take up the cases when there are circuit splits. Or the court can just let the split persist for a while, and federal law will mean different things in different parts of the country, but that's not ideal. So indeed, one of the arguments in favor of Chevron, not mentioned the Chevron opinion itself, but that other scholars, for example, have articulated, is it's a useful management tool for the Supreme Court. It takes more of these administrative law issues off their agenda. So they could still weigh in on the ones they really care about, but you might have a bunch of not very exciting, like maybe a little bit technical, but still kind of important issues of federal law where different courts of appeals are reaching different conclusions, and now the Supreme Court has to weigh in to resolve the split. So there's a little bit, Patricia, to your earlier question about will this affect the number of cases the court is taking, this would be one of the ways it would increase it, because now there's just more disagreement that the courts got to deal with. And it'll be interesting to see how they handle it. It'll be interesting to see how big of an effect it is. They might find themselves in the position where they want to issue some clarifying doctrines or some doctrinal modifications to kick more of these cases out. It's probably not going to overwhelm them. I mean, they're not going to get flooded. There was a world before Chevron existed, and the court, survived then. It wasn't like there were hundreds and hundreds of circuit split cases every year. They decide fewer cases now than they used to. When one of the most prominent scholars to make the argument that I was just describing, that Chevron is a useful management tool for the Supreme Court, was Peter Strauss, who wrote this paper called 150 Cases Per Year. And there was a subtitle. Well, back then when he wrote it, in I think the late 1980s, the Supreme Court was deciding 150 cases per year. Now it's something like 60, right? So it is true that their docket has fewer things on it, so there might be more upward pressure. But yeah, I mean, the short answer to your question is, if it is true that overruling Chevron will lead to more what we call circuit splits, where different courts of appeals reach different conclusions, then there will be more cases that the Supreme Court will feel obligated to resolve. And by the way, therefore, more issues that will be definitively resolved ultimately by the Supreme Court rather than by the agency. So if you get a situation where the agency issues its interpretation, the courts of appeals that hear it all apply Chevron and defer to the agency, there's much less likely to be a circuit split, so much less likely the court will bother to hear the case in the first place, so the agency's probably going to win. Now, even if it's a case that otherwise the court wouldn't have paid any attention to, it may be more likely to generate a circuit split, so then the court will have to take it, and then the court not applying Chevron will just decide on its own what it thinks the best interpretation is. So this would be another channel through which we're going to be shifting power from the agencies, not just to the courts generally, but to the Supreme Court specifically.
Thank you, Professor. Mais alguma pergunta da plateia? Patrícia, André, Sérgio? Bom, então acho que pelo avançar da hora nós vamos encerrar. Sérgio estava preocupado aqui, já estava me cobrando. So, Professor, thank you again for being here. It was an enormous pleasure. Eu gostaria também de agradecer a FGV Direito Rio, na pessoa do professor Sérgio Guerra, porque o professor Matthew Stephenson está aqui porque a FGV autorizou. Eles foram muito gentis em receber o convite da PGE e aceitar que o professor viesse aqui para compartilhar o conhecimento dele conosco. Então, muito obrigado, Sérgio. Obrigado, Patrícia. Obrigado, André, que me ajudaram hoje nesse evento. Thank you, Professor, and we hope to receive you here again in the future.